All right, boys and girls, we are back with another edition of the Federalist Radio Hour. I'm your host, Ben Domenech. You can email us, as always, at radiofederalist.com. Follow us on Twitter at FDRLST. So follow my guest for the hour today, Ilya Shapiro, on Twitter at iShapiro. He is the author of the book that you see behind you at the moment, Supreme Disorder. He's also the director of the Robert G. Levy Center for Constitutional Studies at the Cato Institute. There's that book with the great picture on the front. I'm curious a little bit about that, but
I have something on that actually.
Yes, I was going to say you just literally finished testifying in front of the House Judiciary Committee. Tell us a little bit about what that was about.
Yeah, I tell you, testifying in shorts and flip-flops is a lot more fun than the way we used to do it. I won't stand up during this podcast. So this was a hearing on judicial independence and the rule of law, the causes and consequences of court capture. And it was sort of part attack on the Federalist Society for being this nefarious organization that has now captured the courts, and part dark money with Sheldon Whitehouse starting off the testimony and talking about Leonard Leo's dark money and all the rest of it. And obviously, given the timing, and this has been postponed and rescheduled several times, we had to address the elephant in the room. So I definitely got questions on, my position on whether Mitch McConnell should, quote, ram through or jam through a nominee now. And I was trying to give my historical background from my book. And he's like, well, no, taking back my time. Anyway, it was an interesting experience. My first time in the House. I think I've testified in the Senate 3 or 4 times. It was the first time in the House and virtual at that. So an interesting experience.
The context of this book obviously has to be big for you as well, just given the current moment. How has the reaction to it early on been?
Well, the Amazon pre-orders were pretty good. I'm basically duking it out with Ted Cruz, whose book they advanced the publication a week. It's coming out next week, and a compendium of Justice Scalia's legal writings, The Essential Scalia. So that's pretty good company on the judicial branch bestsellers. I'm like in the top 10 in the Congress and Senate newly released bestsellers on Amazon as well, trailing only like Obama, John Boehner's new book now, and something else. So this is interesting. My publisher's happy. They already this past weekend they ordered a second printing before today's official release date. So yeah, the timing, while unfortunate, of course, couldn't be better for my book.
Mm-hmm. The central aspect of these court fights to American politics is historically a relatively new phenomenon, isn't it? Where does it come from?
Well, it's new and old. So we had contentious political fights over nominees from the very beginning. George Washington had a nominee rejected. About half the presidents have. But politics has began to play a different role roughly in the late 60s. And in 1968, when LBJ became a self-anointed lame duck, and Earl Warren, the Chief Justice, who had presided over 10, 12 years of radical expansion of federal power, different things that have been characterized as activist, although I don't like the term activist because now it just means something I don't like, basically. But anyway, and he was stepping down. LBJ wanted to elevate Justice Abe Fortas and then nominated somebody to replace him. And Fortas got into a heap of ethics problems, bipartisan opposition, and Nixon ended up replacing Warren. And then Nixon had 2 people rejected for various reasons. Anyway, that's where the saga starts. And then Bork comes in the mid 80s when a year after Scalia had been confirmed unanimously, the Democrats took over the Senate, and Judiciary Committee Chairman Joe Biden led a process of what's now known as borking, right, which is demagoguing his. It was clearly they didn't like his judicial philosophy, but they demagogued it all out of proportion, and away we went.
Prior to Bork, what significance was attached to any kind of ideological positioning or judicial philosophy on the part of a nominee? In other words, were most of the people who were rejected before rejected for reasons having to do with corruption or their political positioning, as opposed to what philosophy they would bring to the court?
Well, typically a lot of this would happen before the nomination process. So the president wouldn't pick someone who he didn't find simpatico or politically allied. or would do the right thing on whatever the issue of the day is. Lincoln with the expansive executive power, or Andrew Jackson in a kind of a small, returning power to the states, or during the early republic, standing up the Supreme Court and the federal government, a Hamiltonian view in various ways. Teddy Roosevelt and then his successor, William Howard Taft, at the beginning of the 20th century, really started the idea of picking a nominee's, quote, real politics. So it doesn't matter what party or party faction you belong to. Teddy Roosevelt wanted a progressive who would bust trusts or support the busting of trusts. William Howard Taft was more deregulatory, more of a classical liberal, wanted to move in that direction. But it's hard, even back then. Woodrow Wilson, who succeeded in turn Taft, had 3 appointments, one of whom was a great progressive hero, Louis Brandeis, whose confirmation process was actually, I think, the most controversial in our history, beating Bork and Thomas and Kavanaugh. Took 5 months, longer than anyone else. First ever hearings. We didn't have hearings before Brandeis in 1916. Now, the nominee himself did not testify because that was seen as unseemly, but he was a social crusader, very politically controversial. Anyway, that was Woodrow Wilson's one. Another one was James Clark McReynolds, who was the most opposite to a progressive, kind of a reactionary, one of the 4 horsemen that would end up voting against FDR's New Deal programs. Also kind of an ornery, bigoted, just very personally obnoxious person. Even a couple of justices who generally voted with him left the Chevy Chase Country Club because they didn't want to be around him, let alone Brandeis, who, because he was Jewish, McReynolds didn't want to be around. So but agreed with Woodrow Wilson on one issue, antitrust. Okay. So one thing. And then a third justice that he appointed, James Hessen Clark, that was completely inconsequential. So, it's hard to judge these things. Some presidents tried to find cronies or balance regional power or factions within their party or something else like that. Some cared about one particular issue, be it slavery or preventing civil war, executive power, or regulation, or what have you. Others did different things. But now it's quite clear that it's about judicial philosophy writ large. And we also have the culmination of several trends on top of that, where that divergence in judicial philosophy maps onto partisan preference at a time when the parties are more ideologically sorted than they've been since at least the Civil War, if not ever. And so, of course, the battles under those circumstances are going to be fraught.
Ilya, there's a real change, I think, in the nature of the way these court fights play out in the public square compared to even a few decades ago. I remember coming to Capitol Hill when there were a lot of fights surrounding President George W. Bush's nominees and seeing the interactions that the staff had that were basically about, we can't believe that they're holding up someone like Miguel Estrada just because they're afraid that he's going to be someone who could advance to the Supreme Court. Those were a lot of fights at the time that seemed to mostly be DC-based context. In other words, people really weren't familiar with them outside of the very politically active and engaged. What changed in terms of these becoming public, national, real things that engaged the activist bases of both sides, as opposed to being just things that were kind of really just Washington debates that didn't really translate out into the mainstream?
Well, like rich families becoming poor, it happened gradually and then suddenly. I mean, there were a series of escalations. Going back, I like to talk about the New Deal court that started implicitly allowing constitutional amendments without actual amendments. But then you can talk about the Reconstruction era court that subverted the 14th Amendment and other related reforms. In the modern age, people talked about Roe v. Wade, but the first justice appointed or nominated after Roe v. Wade, the first few, there weren't any questions on abortion really asked until Bork came along more than a decade later. With the lower courts, it's just one more escalation. So basically, Bork happened, relative calm for Ginsburg and Breyer under Clinton because the Democrats had the majority. And that's a key to understanding this whole nut historically. When the Senate and the White House are controlled by the same party, about 90% of Supreme Court nominees are confirmed. When it's different parties, it's about 60%. So that's the whole ballgame. But In late Reagan, a little bit under first Bush 1, and then under Clinton, lower court judges became part of this battle. The Democrats kind of test drove their attack Bork strategy on an otherwise obscure nominee to the Ninth Circuit, one of the most libertarian nominees, frankly, in modern era, Bernie Segan, to the Ninth Circuit. He was a professor at University of San Diego, and it worked there, and so they took it to Bork after that. But then, Republicans obstructed Clinton for a time. Then at the escalation after that was the Estrada and the filibustering for the first time ever, the partisan filibustering of nominees by Harry Reid in 2002, 2003. And it went from there. And, we just see one escalation after another.
I wonder about the personal side of this. There's an argument that I've seen advanced by a number of people online that essentially Democrats have engaged in an escalating series of personal assassinations when it comes to the high court, Bork, Thomas, Kavanaugh, et cetera, and that rather than make this an argument about the ideological perspective of the people involved or their philosophy, that they've really gone into that direction. Do you believe that that's something that in the post-Kavanaugh era is going to continue to be a major aspect of these nominations? Or is it something where, because of the perceived political backlash to that, namely a number of Democrat senators losing their races, a number of Republicans who defended the Kavanaugh most strongly winning their races, that the lesson taken away was basically this is a potential double-edged sword to engage in this type of behavior when it comes to nominees?
Yeah, I think it is. The escalations have been on both sides, but the personal attacks have been by Democrats. Now that I think about it, there certainly hasn't been an equivalent. In the last 30 years, the Democratic nominees have been Ginsburg to the Supreme Court, Ginsburg, Breyer, Sotomayor, and Kagan, and there were no personal attacks there at all. And I think in the lower courts as well, Republicans have been ferocious at times, but purely on ideology and judicial philosophy. I don't recall personal attacks. Even something like, Dianne Feinstein's line to Amy Coney Barrett that the dogma lives loudly with you, which sounds like a rejected line from Star Wars. You don't have that kind of equivalent going the other way. And I think it might be kind of the perceptional asymmetry. Even though Republicans care about courts a whole lot, Democrats seem to think that if you disagree on certain issues, it's not that you're just wrong or read the Constitution wrong, but you're a bad person. You're bringing evil and unfairness and injustice. And so that kind of attitudinal asymmetry is playing itself out.
Mm-hmm. I am obviously curious about your thoughts, given the current makeup of the court, the impact of a new presence there, regardless of who the ultimate choice is from the president this week. What do you think the impact will be on the makeup of the court, and particularly the impact on the Chief Justice? John Roberts had been seen as being effectively the swing vote in the wake of adding Justice Gorsuch and Kavanaugh. Do you think that how do you think he's going to adapt to having a new additional conservative nominee potentially on the court?
Yeah, if a Trump nominee is confirmed, then Roberts will no longer be the median vote. I don't call him the swing vote so much, because he's not a squishy moderate that's unsure of where he wants to go. He plays this strategic game, but anyway, he is in the median, in the middle of the court jurisprudentially, which we haven't really had a Chief Justice do that. Briefly, Earl Warren, but that court was so skewed to the left it didn't matter at all. Really, going back to Charles Evan Hughes in the late 30s. And that would mean that the median justice becomes either Kavanaugh or this new nominee, which is a different dynamic. There were a lot of talking points about Roberts that he's not going to be willing to be the fifth vote to do X, whatever conservative originalist goal might be, but he might be the sixth vote. Well, he's going to have the opportunity to be that sixth vote if he really wants. On the other hand, he'd have the opportunity to cost-free make it a 5-4 and make it bipartisan and make the court, would a 5-4 court that way look better than just 6 Republican appointees over 3 Democratic appointees? I'm sure John Roberts, if this happens, is going to spend a lot of time thinking about that.
The major issues that will be impacted by this, obviously, RBG, held a position on numerous issues that will probably be at odds with whoever is put forward by the president. Assuming that he is successful in adding this person to the court, where are the most significant areas of law that we're likely to see a major shift based on this addition?
Well, I think even before Ginsburg's passing, the next affirmative action case, be it the Harvard litigation that's going on now or something else, that already probably would have shifted, because this is an area where Kavanaugh definitely is more solid than, meaning against racial preferences, than Kennedy. And this is an area, racial issues in general, civil rights, where Roberts himself is solid. He's the one, after all, who wrote that the way to end racial discrimination is to end discriminating based on race. And so that's becomes even more of a surer thing. Abortion regulations, not Roe v. Wade itself or Planned Parenthood versus Casey. I don't know if there's currently more than one or maybe two votes to overturn those. But the case that we saw this past term, Jew Medical, kind of regulations around the edges, those are now going to be upheld rather than invalidated. All the cases that we think about as 5-4 cases and might go any which way, whether under Kennedy or now with Roberts playing the strategic game, those would be, less of a, more predictable perhaps. Whether in the area of campaign finance, where Roberts was not the fifth, where Kennedy was not the fifth vote, Roberts was. Now, pretty sure that would be more secure. Second Amendment, they declined to take up all of these Second Amendment petitions this year because presumably Roberts told them, you can't count on me. Well, now Roberts becomes less relevant on that, and they start defining the scope of that right. Pretty much any, top line controversy. Now, somewhere the 5 votes were already secure, so it's not so much of a shift. But anything that was uncertain about and people were wondering, well, where was Kennedy going to go, or now where is Roberts going to go? Those are going to be, more certain.
There's obviously a leading candidate in this current situation. Amy Coney Barrett was discussed last time around, is a little more familiar to people than the other potential candidates for this job. Tell us a little bit about her, to the degree that you've paid attention to her decisions and record. What would she bring to the court?
Yeah, she was one of the finalists 2 years ago when Kavanaugh was ultimately picked. And at that point, she hadn't even been on the Seventh Circuit, hadn't been a federal judge for more than, I think, 6 months or so. Her record at Notre Dame, she was a professor at Notre Dame, was one of a sterling intellect, somewhere between Thomas and Scalia in terms of originalism and textualism. She critiqued very nicely Randy Barnett's book, I think We the People, or our Republican Constitution, rather, in a way that makes me a little uneasy about her view of unenumerated rights in the 14th Amendment, perhaps as a classical liberal judicial engagement type, but again, somewhere that's a generation removed and therefore better from my perspective on those issues than a Scalia, say. Very nice person, got a great personal reputation, and her writings on the bench have been wide-ranging, and you could accuse her of auditioning. She's written some concurrences and dissents that were very, more than she needed to do to make the point, whether on the First Amendment, the Second Amendment, government powers, a range of issues, and really has established her legal chops.
Florida's Barbara Lagoa has received more attention in recent weeks, including, being touted within the Politico, the Washington Post, and a couple of others as being a potential alternative route for the president to go. What, to the degree that you know her record, do we know about her?
I don't know much of her record because she's been on the 11th Circuit less than a year. She was on the Florida Supreme Court less than a year before that. And before that, she spent 12 years on the Florida Intermediate State Court. And I'm sorry, Ben, I'm a legal nerd, but I don't spend my time reading state intermediate court opinions. So as we speak, I have a couple of associates, and an intern trying to read the important cases from that and put a memo together by the end of the week, so I'll be able to talk intelligently if indeed she's the nominee. But it's an interesting discussion because so many people that legal elites, conservative legal elites respect are vouching for her. I mean, she's the talk of the Florida legal community, Florida Federalist Society and all of that. But it's almost like a Souter situation. That's great. So and so and so and so and so and so are vouching for her, but I'm not going to get burned again. And of course, there's the political element because she's a Cuban American from Florida, which adds something, perhaps. Not that Floridians have heard of her either. But then again, Amy Coney Barrett adds something to Catholics and evangelicals and others who maybe not Republicans, maybe don't like Trump, but care about whether the abortion issue or something else in a way that would bring them back into the fold.
Of the rest of the names on the list, assuming the president sticks to the list, is there a dark horse that sticks out to you, given the fact that he's already said it will be a woman in terms of who he chooses?
I mean, that already limits us to, I think, the full list is 44. You take out the people who are older than 55, because that's unrealistic these days, which unfortunately takes out one of my top choices, Diane Sykes of the Seventh Circuit. She's fantastic. She's turning 63 in a couple of months. So, the people Allison Jones Rushing gets mentioned. She's way too young. She's 38. She's been on the Fourth Circuit, I think, a year. I think she'll be a superstar in future such contentions. I think they're probably elevating her to talk her up for that purpose, but highly unrealistic. Kate Todd, in sort of a Dick Cheney moment, she's the point person in the White House on judicial selection, the deputy White House counsel, former Supreme Court clerk, former head of litigation at the Chamber of Commerce, has done a bang-up job at the White House. But she's been a different kind of practitioner, and so doesn't have a judicial or academic record. And again, people vouch for her. I've met her a couple of times. Who knows? If they were sticking to the Don McGahn standard, that would not be good enough, because they wanted a rock ribbed prove when on paper you have publicly taken controversial positions kind of a situation. Joan Larson of the Sixth Circuit, Allison Ide of the 10th Circuit, a couple of more women on the appellate courts. They all have something to commend themselves. For whatever reason, they're not being discussed as much. They're a little different. They're kind of like, Ide is more like Alito, more law and order. Larson is more academic and was also on the Michigan Supreme Court, kind of bread and butter, just doesn't try to go for headlines. They all have different things to commend themselves. Certainly, can't really go wrong. I mean, none of those is going to burn you, I don't think. But it sounds like every indication we're getting is that it's either Barrett or Lagoa.
Mm-hmm. Talk to me a little bit about the cover picture on your book.
Right. So this woman, Jessica Campbell Hansen, I believe. I'm going to get the last name wrong. I forget her name. She is so through the magic of Twitter, somebody connected us. In the Kevin Bacon game, I'm 1 degree of separation apart from her. She is not a professional activist. In fact, she's a JDMA, who's a political consultant in Colorado, happened to be in D.C. to meet with her Senator Cory Gardner on some violence against women legislation or something like that. And right during all this brouhaha over Kavanaugh, and I think Mitch McConnell shut down the Senate, and she was complaining she couldn't get in fully or something. And so she saw this rally and decided to go up and sit on Lady Justice. And so we had this Twitter DM conversation last week, just when we got connected. And after that, a phone call, and I tried to drum up some media interest. This would be maybe an interesting personal interest story, because we had a very civil discussion after RBG died. She texted me, well, and I replied, well put. So someone that I actually had an interesting, intellectual, informed conversation with, which you wouldn't necessarily expect from this picture, but that's it just shows you can't judge a book or a person by a cover.
The conversation that we're likely to see play out in the next couple of months is going to be incredibly intense. Already we've seen, the invocation of rioting in the streets, violence, and the like. The Supreme Court is not supposed to occupy a position of such power in American life. It was never designed to be that way by the founders. And yet, in the absence of a functional Congress and legislative branch, it seems to occupy this outsized importance in all of our lives. Is there any possible path to getting to a point where when there is a replacement of a Supreme Court justice, there's not a massive nationwide partisan freakout, but rather just an understanding that this is, a job that someone needs to do when it comes to adjudicating the law?
There are a lot of game theory elements to this. When is the vote? What is the result of the election? What happens during the confirmation hearing? I mean, that is going to be a moment both in our Supreme Court battle trajectory and in the election, because for one thing, you're going to have this unprecedented scenario of the Democratic vice presidential nominee on the Judiciary Committee, Kamala Harris, questioning whoever the nominee is. That's going to be interesting and should affect something. The court, you're right, should not be this important. And the reason why we have these battles is precisely because it's important, and precisely because, as I described, we have the different approaches to what the justices should do. So, to give away the ending of my book, I don't have any magic bullet solutions for reform. It's just a matter of unwinding this centralization of power in Washington, and then within Washington, the skewing of that power towards the executive branch, towards administrative agencies, away from Congress, hashing out these differences in values or clashes in policy that we might have. If we were designing a Supreme Court from scratch, we'd probably want more than 9 people on it, because presumably there'd be fewer 10-9 decisions than 5-4. We'd probably want term limits, not to change the functioning of the court, but to avoid these kind of morbid health watch of octogenarian justices and other kind of random or politicized decisions to depart or not depart. But we're not writing on a blank slate. And term limits, for example, and certain other kinds of reforms, although not changing the court size, would require a constitutional amendment. So they'd be hard to do. I actually have my first ever piece in the Atlantic today on term limits, saying, yeah, it would probably increase public confidence, but it's not a panacea, wouldn't change the ideological balance of the court over time, et cetera. So I don't think there are any structural or really reform propositions to be able to be had. All of these proposals are rearranging deck chairs on the Titanic, and the Titanic is not the process, it's the product. It's the ship of state, which if only our constitutional order were rebalanced, both in terms of federalism and the separation of powers, that's the only way to solve these issues and repel the toxicity that's enveloped the court.
Mm-hmm. One more question before we wrap up. I feel like there's an element of this that has to be acknowledged, which is the unwillingness of our elected leaders supposed to represent us to decide many of these issues for themselves. That instead, they actually like a situation where it's unelected, court-appointed, lifetime tenured people who are deciding these matters, and not, the Congress, and not people who have to see the voters every 2 or every 6 years. To me, that's just such a fundamental problem, one that is really difficult to wrestle with, that it crops up in almost every area of policy, from small things to big things. They just want either send it over to the bureaucracy for them to resolve these questions, and then fight that battle out in the courts and let them resolve it, while we act as hype men for our various partisan sides. I don't know how to change that, and I still have yet to hear a strong argument from any of the institutionally minded folks about what could be changed in order to alter that scheme of things. Do you have a solution?
Yeah, this echoes how Ben Sasse began his remarks at the Kavanaugh hearings. Both parties do it when they're in charge of Congress. They prefer to punt the big issues so they don't have to, they can just pass the Truth, Beauty, and Goodness Act of 2020 and let the regulators flesh that out. And when people get hurt, the congressmen and senators say, well, that wasn't me, that was the bureaucracy. And all the branches are to blame for this. The bureaucracy for taking all that rope and then taking even more, and the courts for allowing Congress to get away with that kind of delegation. I mean, lawyers call this the non-delegation doctrine, which It's an oversimplification, but essentially has had one good year in American history. In 1935, a couple of pieces of legislation were struck down as delegating too much legislative power to the bureaucracy, but not since. There might be a revival of that, but ultimately, if Congress is allowed to get away with that sort of thing, then they're going to do that. And there's a famous example of this with the McCain-Feingold, the campaign finance reform in 2002, where congressmen were making speeches saying, "I have no idea whether this is constitutional. We'll send it up. Let the Justice Department figure that out." And then President Bush got it, said, "I have serious doubts about some of this. I'll let the court sort it out." And then it got to the Supreme Court, and effectively Sandra Day O'Connor said, "Well, we'll just defer to Congress. They thought about this, and so they take their oath seriously." And it's a vicious cycle. And you're right. It's going to take self-discipline by each of the branches to fix.
Mm-hmm. Ilya Shapiro's book is Supreme Disorder. You can follow him on Twitter at iShapiro. Thanks so much for taking the time to join us today.
Thank you, Ben.
I'm Ben Domenech. You've been listening to another edition of the Federalist Radio Hour. We'll be back soon with more. Until then, be lovers of freedom and anxious for the fray.